No sure for the custody matter. Lady was sent behind the bars. The last order is it was reflected, may I point out to your lordship? As a respondent is to be released from judicial custody on 23 or 24/9. List the matters on 25/9. It's listed, not listed, but may come in the supplementary list tomorrow. May come, lordship, it hasn't come in the.
Today is 24.
Today is 24. What happened, your lordship?
Tomorrow.
Yes, day before yesterday, I don't know what any release order is passed, but I don't know, I'm not aware of. Forcefully, the child was taken away
I hope.
by the mother. She created a scene. Prior to that, the previous day, the mother of this one, respondent, this one, present appellant expired, your lordship. Video recording, lordship,
We expired.
mother of the appellant. They are in bereavement, yes. 21, mother expired. 22, I don't know from how. Like she entered my residence along with the lawyer. His visual was seen in the CCTV. It was recorded. Not CCTV, in the video recording, yes, camera. So she was supposed to be using abusive language, is your lordship. Lordship and law.
Let it come tomorrow. You give a affidavit.
Additional affidavit, we are going to file it. It's under process.
You pick up tomorrow, correct?
Yes, but the lordship mainly says hasn't come.
You take a very big.
Yes, it's ready for tomorrow. I know. Because custody order for the child was until father orders. And lordship, if your lordship sees the video, the welfare of the minor is the best, your lordship, is the stake as the way she behaved, my lord, as the way.
That for that, there will be paid guardianship of the child.
Regarding
Guardianship of
lots of I have.
No. Is there any case pending before any court?
No, against the guardianship, we have come. My case was rejected.
Correct.
So we have come up before this honorable
So
court.
we have to decide that
Yes, that is
that
different
will be
aspect.
decided at one go.
Lordship,
That will be decided from hearing.
at the time of hearing.
How come?
But in the interim, lordship,
Correct. Have you filed any contempt? Have you filed any contempt? Because you see what you're saying now. Because he has violated the. Have you filed any contempt to take up to the latest?
most of the things we file.
You need to file a contempt.
Yes, also we file.
You file a contempt because you take the 50th subsequent cause of action.
And your lordship, it's a part of that settlement agreement. They entered it
Remember,
into.
okay,
No, my lord.
If you have contempt of the last order passed by.
My lord, we will.
You will file a contempt. You will discuss everything tomorrow.
My.
Wait, please, your lord. I beg to mention item number 1 in today's daily list.
Yes.
I'm for the sole respondent and my learned friend appears for the appellant. I've taken their consent, my lord. I need the matter and be adjourned for the 1.
Right. On the prayer for adjournment made by Mr.
AK Boro.
A.K. Boro. Then counsel for the response which is not objected to by Mr.
KJ.
K.J. Then counsel for the appellant. Is the matter after the meeting.
Okay, sir.
Appellant has already been admitted. Today's IA for bail.
Yes, sir. That's a health point number 2.
Lordship, sir, we have received this one.
Okay.
Report, man.
Okay.
Vanessa Khatun. Lordship, actually, in this case, file objection before
He
Cecilia.
has not filed objection.
File of objection. Yes, proceed. Sure. We'll be filing it until it's ready, now. We'll be filing it in the course of the day. Anissa, please.
Yeah, we'll discuss after the meeting. Right. In the appeal, you right. Mr. S.K. Podar appears for the applicant. Yes. Here. it is submitted. As submitted.
You have taken steps, Lord.
As submitted. A letter dated 24/9/25 issued by the ASI of Moregaon, PA, which is to the effect that the notice along with a copy of the memo of appeal has been duly served upon the respondent number. Write the said letter. The ASI has further stated that the respondent number two has been informed that if they have no means to engage a lawyer, they may apply for legal aid. No one appears for the respondent number. The notice is accordingly deemed to be served on the respondent. As PCR has been received, registry to prepare the paper. This is the matter after 4 weeks.
On 17.
They will not be able to complete that.
No, so far IA is confirmed.
Yeah, this is the matter after 4 weeks. This is the matter of 4 weeks. Then in the IA, right? Ms. B. Boyan. Additional PP submit that he will be filing the written objection to the application within the course of the. This is the matter on 22nd. Applied.
As per last order dated 14/8, a report was called from the chairman of Mental Health Review Board,
No report.
but no report.
So we'll have to wait. Right. As there is no report submitted. From the chairman of the Mental Health Review Board. From a Kamrup and still to the matter is adjourned till. Till. Leave the matter on 20.
Obliged. The IA has been by that, looking order for following the delay of 32 days, my lord, in filing the appeal.
Let Mr. A. Sarane, learn counsel for the applicant to submit that there is a delay of 32 days
My lord.
in filing the appeal against the conviction of the offender. Under section 6 of the POCSO. This may be up, but it should be submitted that there was no objection to the delay being. Accordingly, the delay is also. Registry to list the appeal after the petition. As accordingly.
The counsel for the, my lord, the applicant and the applicant has been not shown properly. That may be only one advocate's name is shown, very difficult, my lord, until unless my name is shown, my lord.
The name is there.
My lord, it's not my name, my lord, it's only one,
Oh. A. Saranya.
my lord,
A Kaito Saraswati.
my lord.
Oh, yeah. Registry to also reflect the name of Mr. M. Saranya in the call.
My lord.
He's
my
a
lord,
son.
My lord. My lord.
This is the appeal which is preferred, impugning the judgment of the honorable single judge. With regard to the matter that the termination of the husband of the petitioner was not eligible, your lordship. And on the last occasion, your lordship has partly heard the matter.
Your Lordship, the plea of Rule 2.7 of SBI rules, which they are pleading at the appellate stage, At no point of time, they pleaded the truth.
Let, 2.7 requires, I think, 3 notices.
Three notices and three notices that too after a duration of 30 days.
Yes.
But if
So
the-
each notice has to give 30 days time period.
Yes, your lordship, and if your lordship consider the notices sent by them, as your lordship recorded on last occasion, the duration is not 30 days from one notice
So
to another
2.7 is not applicable.
applicable, and it was not even in operation in 2002.
Why?
Because it has come into effect from 6/6/2005.
Where do you say that?
Your lordship, on their rules, and the page number 72 of their rules,
The page number 72.
on the last pair.
Huh?
On the last pair of their SBI HR handbook.
Is it here?
HR
HR handbook, I have placed your lordship, one copy there.
That's a big.
Page 72.
Page 71, your lordship.
No, we don't need to see that. 71 will be. 71. No, not on there. Come on there.
So that, lordship, that handbook, your lordship, it's a compilation.
Ah.
And the regulation which is framed is formed by a memorandum of settlement, which is entered between the bank employees association and all the banks, your lordship. And
So as and when
yes,
but the thing is that he's saying this 2.7 was not in existence
lordship,
in 2002.
Yes, your lordship.
the regulation, your lordship, it is as per the settlement 10th April 1989.
No, Mr. Kaur. The issue raised is as to whether this particular regulation 2.7 was there in the year 2002 or whether it came later.
No, it was there, your lordship.
It was there.
Yes,
Your lordship, kindly turn page number 71 and 72 of their HR handbook.
Yes.
That is the rule laid down on page number 71.
Correct?
And on the page number 72, last para, your lordship will see the memorandum on the basis of which the rule is coming into existence. That is effect dated 6/6/2005.
That is with regard to a
2.7 is coming into existence by dint of the memorandum, and the memorandum is.
This TTO IR
Yes, your lordship.
91.
Right.
Yeah,
that is a circular, your lordship, which is circulated in all the different branches of the bank to comply with the guidelines that is set on memorandum settlement. I have the circular, your lordship. I'm sorry, your lordship, only one.
everything is one.
It is a circular, and at the second page, your lordship, the procedure against which the cessation can be done is laid down, your lordship.
Forget about that 2002 or 2005. Let us see whether the procedure required under 2.7 has been followed on.
Your lordship, 2.7, your lordship, it speaks about two notices. Two notices, your lordship. If your lordship will kindly take
Let us see.
2.7.
Ah. When an employee,
When employee, if I may, your lordship.
Yes.
When an employee absents himself from work for a period of 90 or more consecutive days without prior sanction from the competent authority or beyond the period of leave sanctioned originally, including any extension thereof, or when there is satisfactory evidence that he has taken up employment in India or outside, the management at any time thereafter may give a notice, not a first notice, to the employee at his last known address as recorded with the bank, calling upon him to report for the work within 30 days of the date of the notice. Next page, your lordship, page number 72. Unless the employee reports for the work within 30 days of the notice or gives an explanation for his absence within the period of 30 days, satisfying the management inter alia that he has not taken up another employment or avocation, the employee shall be given a further notice, the second notice,
Correct.
to report for work within 30 days of the notice, failing which the employee will be deemed to have voluntarily vacated his employment on the expiry of the said notice and advised accordingly by it. So there is only mandate of 2 notices.
Then we connect.
In the event of the employee submitting a satisfactory reply, he shall be permitted to work for thereafter within 30 days from the date of expiry of the aforesaid notice without prejudice to the bank's right to take any action under the law or rules, conditions of service. And thereafter, if he reports within that period, he replies, then another. So the mandate is only that 2 notices required to be sent. However, the bank have sent 3 notices.
No, so the thing is like that. 2 notices, if he doesn't come back, then he is deemed to have voluntarily vacated his employment. However, in the event of him submitting a satisfactory reply to the second notice, he shall be permitted to report within a period, a further period of 30 days. However, if the employee fails to report within that extra period of 30 days, that means 90 days, the third 30 days, then he is to be given a final notice to report forward within 30 days, failing which employee will have voluntarily vacated his employment. You see, there are two aspects to this 2.7. One is if within that 2 months, that 2 notices period of 30 days each, he does not submit a reply or does not rejoin, then he is said to be deemed to have voluntarily vacated his employment. However, if he submits a reply within time, on the basis of that second notice, then he has to add, but he does not join, then he has to be given a final notice. Out here, in your case, you were given 2 notices. Now, whether those 2 notices gave 30 days period each, we'll have to see that.
No, you're not sure.
Let us see.
If we consider the last 2 notices,
Let us see from the first, not the last 2. We have to see the first 2. That is the most.
yes,
Let us see the first 2. Where is it?
First notice is at page number 62, Lordship.
First, just page 62 dated.
Dated 8/5/2002, Lordship.
Oh, no, prior to that, there is 9/1/2002 also. What are you doing? You also don't even know your page.
yes,
Lordship.
Your Lordship. Yeah, prior to that, there was
Yeah,
one.
He was, Your Lordship, he was consecutively absent. He was,
Mr. Counselor, which is the first notice?
Lordship, it is on 61, Lordship.
Huh?
Page number 61.
Then why are you saying 56?
But Lordship, thereafter he had joined, Your Lordship. He had again joined,
Okay, he has joined.
Lordship.
After 9/1/2002, he joined.
Joined, Lordship.
Just a minute. Okay, so notice 9/1/2002. He joined when?
Your Lordship, the joining notice is not here, Your Lordship, but last reporting of 17/4/2002. Since 17/4/2002.
So 17/4/2002, he joined. Then the first notice when?
Yes, Your Lordship.
At page
62.
Your Lordship, last, he said last reporting on April, not date of joining of us.
No, it doesn't matter. So how does that matter? So 8/5/2002 was the first notice after he again disappeared. Correct? So 8/5/2002. Yeah, therefore within 7 days. They have not given 30 days time.
Lordship, here it is 7 days.
Then this does not this cannot be deemed to be a notice under section 2.7. Then come to the second notice. Where is that?
Subsequent page number 63, Your Lordship, dated 15/5/2002.
15/5/2000.
Lordship.
And this gives 30 days time. This can be deemed to be a notice under 2.0, but this have to be deemed to be a first notice.
Lordship.
Then what is the next notice?
Your Lordship, the page number 64, dated 13/6/2002.
That is not 30 days, Your Lordship.
63 and 64, 30 days.
Okay.
62 is 7 days.
Your Lordship, if you can see that 60, page number 63, 15/5/2002, and 64, page number 13/6/2002, not the duration of 30 days. It's correct. Your Lordship.
How does that matter?
And Your Lordship,
But they've given you 30 days time. They cannot go beyond that.
and the thing is that, Your Lordship, this point, say, 2.7, the rule, they have never pleaded this before the Honorable Single Judge. Only at the appellate stage, they are feeling they are taking this plea. And secondly, Your Lordship, they failed to satisfy the court that it was in operation in 2002.
So, but then you did not rejoin after the second notice, after this 13/6/2000.
Yes, that's failed to them.
You failed to rejoin. Now the thing is that when did this, what was the single bench said with regard to when this 2.7 came into effect?
The single bench is silent about 2.7 because they have never placed this rule before the Honorable Single Judge. Even after a reminder to them again and again, and they never took the plea. They never took the plea of 2.7.
So let it go back before the learned single judge, let him decide on this.
Your Lordship, as the learned single judge considered the employment to be continued because it was not according to.
Yes, you said that he has not considered 2.7.
Because they did not taken the plea, Your Lordship.
So we will. So that is why we're going to ask the court to decide. If you want us to decide, make or waste to.
This is the main issue, one of the main issues.
That's the main issue.
This we consider. Only thing was that his rule was not placed before.
What is your pleadings in your counter affidavit for the land?
Your Lordship, if Your Lordship may kindly take up the writ petition, Your Lordship.
Yes.
Yeah.
Writ petition or why writ petition? Affidavit?
Your affidavit.
Because whether you took up the plea of 2.7.
50 it starts.
Lordship. Here, Your Lordship, the petitioner has came before this honorable court only on two aspects, Your Lordship. First thing is the provident fund, the gratuity, which has been already paid, Your Lordship. And there was an policy, Your Lordship, Sampurna Suraksha SBI Life Insurance and Family Pension Policy, Your Lordship. On that ground, they have came before this honorable court and we have replied only to that aspect, Your Lordship.
Oh, okay.
That's why the point 2.7 never.
We also sought for the pension because the rule 2.2 is also mentioned in our petition, but they have not paid attention to that.
No, let us see the writ petition.
Petition is page number 18, Your Lordship. And
Your Lordship, kindly see page number 23. In the matter of in violation of the
Having said that, the learned Darford came into. Okay.
You have not taken the plea also.
No, Lordship.
I have taken the plea, Your Lordship.
Petition is consists of 4 pages.
Your
What was
Lordship,
there?
kindly see page number 23. In the matter of violation of the provisions of Rule 22(1) of the State Bank
Nothing there, that is there.
Employees Pension Fund.
Nothing there in the body of the. Very vaguely we have stated. Nothing else.
Because the prayer in the petition is only with
Provision what actually violated, nothing has been stated.
Okay, right. Third, beside Guragaon, then founded for the Appellant State Bank of India. Bracket SBI. And Miss S. Sharma, learned half for the respective. Then you take the last para two, para three. Para six, para seven, para eight. Huh. What is this minimum service for pension? Is there in a rule?
yes, Your Lordship, pension rules, Your Lordship.
Pension rule. Okay, right. Para nine, huh? Para 22. No, no, it's a regulation 22 of the State Bank of India Employees Pension Funds Regulations, cover 2009, 2018, 14. Hereinafter referred to as the 2014 regulation. So why is this problem? Huh? That is already there. Okay. Next. We have perused the writ petition and the prayer made therein, which is as follows. Page 28 and 29. Huh? The prayer of the writ petition being only to the being confined only to the aspect of whether he should be granted balance in provident fund and gratuity and family pension, etc. Without there being any challenge made. Without Yeah. Without the kata from without the kata. The question of the applicability of regulation 2.7. No, whatever, take the screen. Whatever. First, I will just follow first up. Next pass. Next pass. The question of whether that follows. No, next pass. The learned single judge had, on considering the above issues, decided that as there were no proceedings drawn up against the late husband of the writ petitioner to remove / dismiss him from service, he would be deemed to be in service till his demise. There was no occasion for the appellant to make the pleadings with that regulation 2.7 of the HR handbook. Which held that, which provided that in the event of an employee not reporting or replying to 2 consecutive notices to report back to work, the employee would be deemed to have voluntarily vacated his employment on the expiry of the said notice. Next para. In the present case, the respondent, the writ petition had gone on unauthorized absence and a notice was initially issued to him on 9/1/2000 to report back for duty. The writ petitioner rejoined his duty. However, he again went on unauthorized absence with effect from 17/4/2002. 17/4/2000. Due to which he was asked to return to work while letter dated 8/5/2002 issued by the appellant within 7 days. the same not having been done. Notice dated 15/5/2002 was issued by the appellant. By the appellant, no? Appellants or appellant?
Appellant.
Appellant, by the appellant. Asking him to submit a page 63,
Page 63, Lord.
asking him to report for duty within 30 days. Was the same not having been done. Second notice was issued on 13/8/2000,
13/6, Lord.
13/6/2000, giving him another 30 days to report for duty. The writ petitioner, however, did not report for duty, and neither did he submit any reply to either of the two notices. So the second notice was issued prior to the expiry of 30 days. The question of whether the same had caused any prejudice to the writ petition would have to be seen. Keeping in view the fact that the petitioner never reported back from duty from 17/4/2002 until his death on 22/2/2016. Uh, in view of the above, facts, we are of the view, that the above facts not having been brought to the notice of the learned single judge, we are of the view that the said matter should be remanded back to enable the appellants to file a additional affidavit with regard to regulation 2.7 of the HR handbook. Point 7 of the HR handbook applicable to the SBI employees. Further, as the writ petitioners council has taken a stand that regulation 2.7 was not in existence in the year 2000, and that it came into effect only from 2006. The said issue could also be decided. The said issue may also be decided by the learned secretary. In view of the reasons thereabouts, we the matter back to the learned single bench to take the fixed decision on the matter after allowing the appellants to file an additional affidavit with regard to regulation 2.7. That's all. Consequently, the impugned judgment and order. Consequently, the order dated 2/4/2024 passed in WPC 6660/2021 is hereby settled. Appeal is accordingly dispensed. What is this? I this paper.
Published.
This petitioner's husband, no, wherever we say this petitioner. No, you just see that, we'll see. Okay.
Yeah, please, your lordship. My lord, this is an appeal against the judgment and order passed by learned Session Justice to my lord, in which case accused appellant would the accused persons convicted under section 447, 323 and 302 at 34 FEC, my lord.
302.
Yes, my lord.
Let us.
Lord,
Just a minute.
before starting my argument, my humble submission, I beg to state that my lord, both the accused persons are husband and wife, and my lord, they are above 72 years. My lord, may I read my lord FIR?
So, there are two appellants,
My lord, husband and wife,
only two convicts.
two convicts, my lord, or,
So there is no other convict,
no, my lord,
only two.
husband and wife convicted, and my lord, as I heard on this 26/3/11, my lord.
Son is there, lordship, he is absconded.
Oh, Sunday absconded. So there was no trial, in the trial he was not there.
No, my lord, absconder. Case was filed against him, who was the main culprit.
Tried by
Land
name.
dispute,
Huh?
lordship, land dispute, and it is between the own brother. This is the brother of
Uncle
the
and
appellant.
Oh, okay, okay.
Land dispute.
My lord, may I read the,
Just a minute, 1 minute, madam. 1 minute. Please wait. Is it under 302 or 307?
302 is added. He succumbed to
Was
his
the
injury.
charge framed under 302?
yes, yes.
Charge frame on the 302, lord. Lordship, in the page
302.
number 7, lordship.
Third one is.
I add page number 7.
Lordship.
Page number 7. Page number 7 is under Bandana Kandulana. Who is this?
He is the appellant, lordship,
The appellant.
Lordship.
And number 2, the Rina Kandulana is the
Wife,
wife. And son John is
447 323 30. Okay. Yes.
my lord, in this case, my lord, 11 witnesses were examined, including MO and IO. And other 1 to 5 witnesses, number 5, minor, they are the hearsay evidence. They are hearsay evidence, they only,
Yes, sir. Yes, sir. Everything.
yes, my lord, and they only narrated the story before the court after hearing.
Just a minute. Just a minute, madam. PW 1 to 5 are hearsay evidence.
They are not present at the time of occurrence.
Not present. Yeah.
My lord,
Any eyewitness?
my lord, item, witness number 2 claimed to be the eyewitness, but after going through the evidence on record, your lordship will find that he is also not the eyewitness. My lord, may I read this?
Okay, madam, you see, it's good that you are prepared, but the problem is you've got to answer our questions also.
My lord,
You cannot go in your own tangent
my lord.
all the time. So the question is there any eyewitness besides PW2?
there is lordship.
There is.
There is a
Oh,
injured lordship CW1,
PW1, injured witness.
injured witness lordship, and lordship PW7,
W7.
lordship there are 5
injured witness,
Five,
5, and they had been treated by Amola,
five injured with.
5 injured witnesses.
So it's a group crash.
It is a group clash. A group clash, but Lordship, in the opposite party, the accused side, Lordship, no one was injured. And this 5 are treated by PW 6, PW 6, Lordship. They had been treated.
Okay, madam, we are ready.
My lord, my learned counsel, my lord, claim that CW1 is the eyewitness. My lord, may I read? The incident occurred in the month
Go
of
to the FIR first.
My lord, my house is adjacent to the house of Bandana, John and Rina. In the midst of the quarrel, John.
The FIR.
No, my lord, with CW1.
No, no, that I have, what query is made, I have answered the query.
Page number.
Page number
I think we have got to be ready for a long hearing now.
No, my lord, no, the important lines I beg to submit, my lord. The important lines, my lord.
Okay.
In this case, my lord, it was a dark night. All the witnesses stated that it was a dark night. My lord only recognized in present Dia. Dia was there and
Which month was this?
yeah, my lord. Page number, kindly come to page number 15, my lord.
March, Lordship.
She's not answering the question.
March.
She doesn't answer.
Oh, March. March, my lord.
You've got a hearing problem. Huh? You've got.
My lord, may I read PW1, my lord?
Please.
PW1, my lord, she has lost the affair, my lord.
W1 is the informant.
Yes, my lord. I know the accused person, namely Bandana Kandulana and Rina Kandulana, the husband and wife, respectively, who are standing on the dock of the court. The occurrence took place on 26/4/2003. Actually, my lord, occurrence took place in the year March 2011, my lord. 2011 occurrence took place, but she stated before the court that occurrence took place on 26/4/2003. First line, my lord.
What it actually took place on?
11, my lord.
Took place on?
She stated, my lord, occurrence took 27/3/11.
27/3/2011.
11, my lord. Day with 26/3 occurrence, 11th occurrence took place, but she has filed the affair, my lord, 27/11, my lord, 14 years back. But she stated,
8 years after the incident.
yes, my lord, but herself stated before the court that occurrence took place on.
Lordship, I'll have to go to the,
Yeah.
no, apni cop LCL, Lordship, because some typographical mistake may be there, Lordship. Yeah, please take it. Yes. 11.
Occurrence took place on 26/4/2003 at about 9 p.m. My lord, I was at my house. The accused persons, Vandana, Rina, and John, who is the son of the accused person, my lord, came near to our house and assaulted my deceased father-in-law, Badar Kandulana. John inflicted the axe blow on the person of the deceased John, my lord, who was declared at absconder file. John Kandulana inflicted the blow, my lord. This is the person of the PW1, and in his cross
PW1, what is the relationship between PW1 and the deceased? Father-in-law, it was a father-in-law, deceased father-in-law.
My lord, page number 15, my lord.
Oh my God.
The police did. The ejaher was written as per my dear dictation. The accused persons are belong to our same family. There is a uncordial relation between the family and the accused, our family, over the land dispute. Kandulana and Ram Singh Kandulana are our neighbors. Junas Bose, many others' house are there. Occurrence took place in our house. Between the house of accused and our house, there is a house of one Ram Singh. But Ram Singh was not examined, my lord.
What are you reading now? What
Not
reading now?
my lord.
What are you reading now?
Page number 15, my lord.
You finished phase.
Lordship, that was typographical mistake by the I, judge. Because the other witnesses, Lordship, they have said that it is occurrences of.
No, that I've seen, yes.
There is.
PW1, my lord, who has filed the FIR, my lord, page number 15 in her cross-examination, she stated. The police did not seize the Dia in the face of which I recognize a accused person.
Which,
We have,
which page, which line you were in?
my lord, 15,
In which line?
which the second para, my lord. Police did not seize the,
Too fast, I'm following you.
my lord. We have 3 rooms. Occurrence took place in the courtyard of the house. By that time,
Which line?
my lord,
Which line?
page number 15, 1, 2, 3, 4, 5, 6, 7,
Read
8,
it from the
9,
beginning.
9 or 10 minutes.
Read it from the beginning.
Let's take a position also. Occurrence took place in the courtyard of the house. By that time, I was the informant in this case. Azahar was written by a police personnel of Salmara Police Outpost. My lord, please. The Azahar was lost on the same day of the occurrence. The Azahar was written as per my dictation. The accused person or belongs to our same family. There is uncordial relation between the family of the accused and our family over land dispute. Louis Kandulana and Ram Singh Kandulana are our neighbors. Junas and many others' houses are there. The occurrence took place in our house. Between the house of the accused and our house, there is a house of Ram Singh, my lord. The police did not seize the Dia, that is Dia in the face of which I recognize the accused person. We have 3 rooms in our house. Occurrence took place in the courtyard of the house. By that time occurrence, we returned to bed, closing the door of the house. On hearing Halla, I stepped out of the bedroom. Firstly, my father-in-law Badur Kandla went of the house and followed him. I can differentiate among thou and X and stick. I stated same facts narrated in my examination in chief while giving statement before police. Hearing hue and cry at our house, neighboring people rushed to our house and found my father-in-law in injured condition. At that time, there was none except our family members present at the place of occurrence. I noticed injured on the back of head of my father-in-law. The police came to the police of occurrence in the given night occurred itself. In the same incident, my husband Salai Kandulana, Sunai Kandulana, after the incident, my father-in-law was admitted in the civil hospital. Then took to Mission Hospital, Tezpur. He was refused to admit at the Mission Hospital. He was taken to Guwahati and admitted in Guwahati Medical College Hospital. My husband was admitted and treated in hospital. After 3 days of undergoing treatment at GMC, my father-in-law died. It is not a fact that I did not state before the police that I saw the accused person assaulting my father-in-law with an axe. It is not a fact that I did not state before police that I saw the accused person assaulting in my flashlight in Diwa. Yes. My lord, I did not recognize the accused person assaulted my father-in-law in the darkness of the night. My lord, page number 16. I did not recall him assaulting my father in darkness of the night, and in view of existence, uncordial relation between the family of the accused and my father-in-law, it was suspected, my lord, that the accused person assaulted my father-in-law to death. This is the statement of PW1, my lord, and PW2, my lord. May I read, my lord, PW2? PW2, my lord. Deceased Badur Kandulana was my father. The accused person, Sri Badur Kandulana and Srimati Rina Kandulana, who was standing on the dock, are my uncle and aunt respectively. The occurrence took place on the day at about 9 p.m. in our courtyard. Occurrence arose on land between two families. The accused persons are there. Son accused John Kandulana came to our house and assaulted my father, Badur. John, my lord, inflicted X blow on my deceased father. Clearly stated that my lord, John Kandulana, was declared as absconder, my lord. John Kandulana, our father, fell down, ground, sustained injuries, and he was immediately shifted to Salmora police outpost. This is the statement of PW2, my lord. He stated that, my lord, John inflicted the blow like this. This is, my lord. Not any statement is not there, my lord, that our accused person was involved in that occurrence. My lord, page number 19, my lord, at his cross-examination, Sri Ram Kandulana, my lord. Page number 20, my lord. He himself stated, my lord, that the assailant could not be recognized in the darkness of the night. Page number 20, my lord. Himself stated that darkness of the night, assaulted could not be recognized. My lord, PW3 is the hearsay evidence, my lord, PW3. And my lord, PW4, my lord. May I read, my lord, PW4?
Yes, yes.
My lord, I know Badur Kandulana and his family members. The occurrence took place 26/3/2011 at about 10 p.m. at the house of the deceased Badur Kandulana. Our house is situated about 200 meters away from the house of the deceased Badur Kandulana. On hearing outbreaking of commotion at the house of accused person, I rushed to their house. When I standing at the courtyard of their house, I saw the accused Bandana Kandulana dealing dao blows to the head of the Badur Kandulana. I saw Bandana and John together dealing the dao. Salai Kandulana on his face, my lord. The deceased and injured were without any arms in their hands. I saw the entire incident in the flash of the candle, Sati, my lord, which was burning in the veranda of the house after witnessing the...
Page number 20, Lordship, it is not the fact is
No, yes, Kobole Nidia.
she
Later
applied.
on you will argue. Later on you will argue. This is the statement of the chief, my lord, PW4. My lord, kindly come to page number 25, cross-examination, my lord. The deceased Badur Kandulana was my village maternal uncle. I address him as uncle. Luis Kandulana, Setia Kandulana, and Mangla Samoa are the neighboring residents of the accused persons. Page number 25, my lord. When I reached the place of occurrence, I did not witness their presence. Accused person, my lord.
From where you are reading?
My lord, page number
Like, you
25.
was just saying the page number 25. From where you are reading? First line, second line, third line, we do not know anything.
My lord, this is the paper book I have received, my lord. This is there, my lord.
Start from the top, first line. Start from the first line, page 25.
Cross-examination. Cross-examination, my lord. The deceased Badur Kandulana was my related maternal uncle. I address him as an uncle. Luis Kandulana, Saita Kandulana, and Magra Sampa are the neighboring residents of the accused persons. When I reached the place of occurrence, I did not witness their presence at the place of occurrence. Initially, there was a hot exchange of words. By the time I reached the place of occurrence, the other neighboring people did not reach the place. Some people were seen standing near the place of occurrence. I could not recognize them, my lord, due to darkness of night. I do not know as to why the quarrel broke between them. My lord, due to darkness.
But he saw Bandana inflicting dao on the head of Badur Kandulana from behind.
My lord, in her cross-examination, he himself stated, my lord, clearly that I could not recognize, and when I reached the place of occurrence, there was not a single person was there. Himself stated in his cross-examination, my lord, I reached the place of occurrence. I did not witness their presence, accused person, my lord, at the place of occurrence.
Where are you reading?
My lord, cross-examination page number 25.
Yes, which para? Okay, the first para.
My lord. Cross-examination of PW 4, my lord. He himself stated in his chief examination in chief that he saw that this is the way, but at his cross-examination stated that he didn't.
Some people were standing near the place of work, I could not recognize them. So he is not recognizing some of them.
But my lord,
Doesn't mean that he cannot recognize all of them.
their presence at
I mean, does not mean that he needs to recognize all of them.
my lord, again, my lord, PW4 stated that police did not record my statement. My lord, I saw Bandana inflicting the blow on the, my lord, police did not record my statement also. In his cross-examination, my lord, page number 2, statement also not recorded, confessional statement also not recorded from any person, my lord.
If they don't want to confess, what to do?
My lord,
If a person does not want to confess, can you force him to confess?
no, my lord,
Then
but IO has requested the police, requested to produce the before the court to record confessional statement. If they do not want to give any statement, that they do not bound to give any confession.
correct. So how does that help you?
And then there is a sufficient, after going through the evidence on record, your lordship will find there is a sufficient contradiction amongst the PWs. My lord, PW5 is the minor hears.
The sufficiency that you're talking about, sufficient evidence, would have to be brought out by you, not by us.
My lord, lordship. My lord, PW5 is the hearsay evidence, my lord, not the eyewitness. MO also, my lord. My lord, again, PW7, my lord. PW7, my lord. He is my lord Susil Hura.
PW5 is not necessary.
My lord,
PW5. What about
my
PW5?
lord, hearsay evidence.
Hearsay. Okay. PW5 is hearsay.
My lord, period, not eyewitness is the hearsay evidence. He narrated the story after hearing from others.
Okay. So no need.
And
Then there are PW6.
6, my lord, MO.
PW6 is MO.
MO. MO, my lord, on 27/3/2011, I attached to Halosya PHC as medical officer. I received a requisition of Solnibara OP GD numbers for examination of Sunil Kandulana, Ram Kandulana, and Sushil Hero, who were escorted and identified by Constable Rizwan, my lord. Sumita Kandulana, 25 years, date and time 27. My lord, on abrasion of the right foreman, measuring 1 into 1 inch, another taking measuring in 1, my lord. My lord, in his opinion, my lord, MO examined as PW6. In his opinion, he stated that, my lord, the injuries were approximately 24 hours old, simple in nature. Simple in nature, my lord.
So,
And caused by blunt weapon.
okay, leaving that aside, we are more interested in the injury on the deceased.
Problem জানানে injury of the disease. আমার রিজন আছে না হয় My lord, PW8, my lord.
Okay.
Dr.
No,
Rokim,
but before that,
my lord.
PW7, what about PW7? Anything? Is he a eyewitness or what is he? Hearsay evidence. PW7. Or you don't want to read?
PW7, my lord, PW7, page number 34, PW7, very important, my lord. Both the accused persons examination in chief, my lord. Both the accused persons are known to me. I also known John Kandulana, who is the son, who is not present in the court today. He's the son, my lord. About 4 years ago, one day at about 9 p.m., I was sitting in the house of deceased Badru Kandulana. At that time, there was an altercation between deceased Badru Kandulana and all the accused persons. My lord, John Kandulana assaulted Badru Kandulana on his head by Dow. John also assaulted on Sila Kandulana on his face by Dow. My lord, but he is not in our place, my lord, only accused person, father and mother, my lord. John clearly stated that John Kandulana inflicted the, my lord. John also assaulted Salai Kandulana on his face by the, my lord, line 3. Page number 34, with PW7, my lord. 5th line, my lord. Clearly stated that John Kandulana inflicted, my lord.
Okay.
Again, my lords,
He does not implicate
my
anybody. But then he says that you and the wife
my lord.
instigating John.
Instigating, my lord.
Page 35, first line.
My lord, cross-examination 30. Police took my statement on that. It is a fact that I have not stated before police on that day that I was sitting in the house of Badru Kandulana. Page number 35, my lord. This is not a fact that I have not stated before police that Rina and Badru Kandulana were instigating John Kandulana to assault Badru Kandulana.
Now you come to page 34. The 6th line from the first paragraph on the right hand side, Rina and Bandhan Kandulana were instigating.
Rina and Badra Kandulana were instigating John Kandulana to assault Badra Kandulana. Yes, my lord, this is land, but my lord, only, my lord, not as other witnesses stated that they are instigated to inflict the father. John Kandulana,
Others have said that this appellant number 1 was also assaulted. Worse.
my lord, all the witnesses stated that there was a dark night and they recognized only in the Diya. But Diya was
Madam, it's a dark night does not mean that it becomes totally dark that you cannot see anything. So, have you gone to the villages in a dark night? Does it mean that you don't see anything that becomes totally dark that you cannot see in front of you? Dark night means dark, but it does not mean that everything becomes and that you cannot see anything. It doesn't mean that. Dark night only means that there's no daylight. That you cannot see far, that's all.
Diya was also not produced before the court. They,
Yeah, what is the question of reality?
my lord, weapon used at the time of occurrence, that weapon also not produced before the court, not
So-
seized by the IO, my lord.
It is an eyewitness.
Important point, my lord, what weapon used at the time of occurrence, my lord?
Madam, when there is an eyewitness, there is no requirement of a weapon to be produced.
My lord, may I read CW1, my lord?
Read CW8. Page 36. What is he? What kind of a witness is he? The
36, my lord, opinion, doctor's opinion.
yes, over the deceased person.
My lord, in our opinion, cause of death was due to come as a result of injuries sustained over the head as described. All injuries were antemortem and caused by blunt force impact, except injury number 1 and 5. However, opinion of treating surgeon is needed. Approximately time since death was 12 to 18 hours. Except one injury number 1 to 5, other injuries are sufficient to cause the death.
See, the injury is so many.
Do injuries here, my lord?
Come to page 39, PW9.
PW9.
PW9 is what? Ayo.
My lord, PW9 is my lord. Name is Dilip Bania.
Is he?
My lord.
Is he an Ayo?
My lord. I was on date, my lord. He said here, my lord, here it was written, my lord, on 6/4/2011. Here did 6/4, my lord. 6/4/11.
Then
Was
26/3/11. Why is the okay, no. So he is the second Ayo.
my lord.
April.
I have already submitted a search sheet in this case against the Badur Kandulana and Srimati Rina Kandulana. John Kandulana's phone absconded. Under section 447, 300 to 34 IPC, exhibit 7 is the search sheet and this is the search sheet, his signature, my lord. PW10, my lord. And PW10 also posted IC in search, my lord.
He is the first Ayo.
My lord. On 27/3/2011, I was posted at IC Salonibari Police Outpost under Tezpur Police Station. On that day, our one Sunita Kandulana filed an Azahar before the outpost where Sunita Kandulana put her signature. Thumb impression was given, my lord. After received the Azahar, GD entry was made by Salibar Police Station and forwarded the Azahar to OCPS for on receipt of the same, registered the case under section Iman and also made a GD entry and endorsed me to investigate the case. On the basis of GD entry, Salonibari outpost, I have taken up investigation of the case, visited the place of occurrence, prepared the sketch map and place of occurrence and recorded the statement of complainant Sunita Kandulana and the eyewitness Ram Kandulana and at the PO. I have also reached the statement witness Susil Hero, Sonas Dhamra, Biswajit Bura, Bosa Hura and place of occurrence. I have sent the injured Salanimura Kandulana, Badar Kandulana at Ram Kandulana to KCS for treatment. I have also arrested accused Rina Kandulana and Bandana Kandulana and forwarded them to the learned court. I have collected the medical report of the injured Sunita Kandulana, Susil Hero, Ram Kandulana. I came to know that one Badru Kandulana was died at GMCH during treatment. Thereafter, on receipt of my transfer order, I have handed over the case diary to Tezpur Police Station. My lord, cross-examination, my lord. I have not seized any weapon. Witness Sunita Kandulana did not state before me that I saw accused person struck her father-in-law by means of an axe and she recognized the accused person assaulting her father-in-law in the light of dia. I did not see any lantern in the case, dia minor. Witness Ram Kandulana did not state before me that John assaulted his father with an axe. Witness Barwa Hura did not state me that as he is the government Gaubura in the village, he took the deceased in injured to the police station by arranging vehicle and further he took the injured to civil hospital for treatment. I have recorded the statement of John Kandare. It is not a fact that Jonas Kandare did not give any statement before me. I have read his statement, recorded his statement. Witness Bisa Benga did not state before me that he received the information about the occurrence from Sukesh. The eldest son of deceased Badru Kandulana and thereupon he rushed to the house of Badru Kandulana. Witness Badur Bengra also did not state before me that when he reached the place of occurrence, he found Salah Kandulana and Badar Kandulana lying injured at the courtyard and their house. Sukesh told me to the effect that Vandana Kandulana and John Kandulana inflicted dow blows to Badar Kandulana and Sadar Kandulana and death in the incident due to recovery cut injury for teeth, Salai Kandulana got unrooted. I have visited the place of occurrence at about 11:30 a.m. I did not record the statement of the scribe of the Azahar. I have heard that Badur Kandulana died GMCH, but I did not visit GMCH. In the Azahar, it is mentioned that Sunita Kandulana was also assaulted by the accused person. On 13/4/2011, I received the information about the death of the Badur Kandulana at GMCH. It is not a fact on suspect. I have arrested Rina Kandulana and Vandana Kandulana. It is not a fact that they were not involved in this case. This is the my lord statement and seat. My lord PW 10 is also my lord in charge of police post Salmora, my lord. PW 10, my lord.
PW10 is the first IO.
My lord. May I read, my lord? On 26/3/2011, I was posted an in charge of Salnibari Police Outpost. On that day at around 12:30 midnight, Badur Kandulana, Salai Kandulana, and Ram Kandulana coming to the outpost informed me that Bandala Kandulana, John Kandulana, and Rina Kandulana had assaulted them, as a result of which they sustained injuries. On the basis of the said verbal information, I made the GD entry dated 26/3/2011 and sent the injured person to KCH hospital for treatment. UBC number so and so, my lord, accompanied the injured person to hospital. I asked the injured person to lodge formal Azahar. Exhibit 8 is the extract copy of the said GD entry number 557/26/2011, my lord. Re-cross examination, my lord. In verbal information, the injured person did not tell me on which date and where they were assaulted. Re-examination of the IO, my lord. Exhibit 8 is the certified copy of the GD entry and number 5 and 5/2016. I have not seen the original GD entry register. It is not a fact that Badur Kandulana, Salai Kandulana, and Ram Kandulana did not give me any verbal information. It is not a fact that Salai Kandulana did not state before me that John Kandulana had cut my upper lip. He told that John Kandulana had cut his mouth. It is not a fact that I did not investigate the case properly. My lord, CW1, my lord, may I read? The incident took place of March 2011 at night. On the day of incident, Bandana Kandulana, John Kandulana, and Rina Kandulana had quarrels with my father, Badur Kandulana, regarding land in front of our house. My house is adjacent to the house of Bandana, John, and Rina. In the midst of the quarrel, John Kandulana gave dow blow of her head of my father. When I prevented, then John had cut my upper lip with the dow. My brother Ram Kandulana prevented and had taken us home, and thereafter we all went to the police station. Police sent to KCH for treatment. From KCH, my father was taken to Mission Hospital. But seeing the condition of my father, he was not given treatment and referred to GMCH. After 3 days, my father expired of GMCH. Due to the dow blow, I lost my teeth upper lip. That was inflicted by John Miller. Cross-examination by the defense. We had land disputes since long. The accused persons are my relatives. I was admitted KCH for 2 days. Police did not seize my teeth. Doctors stitched my cut injury. Late Silai Kandulana, the brother of the accused Vandana Kandulana and Ramsingh Kandulana are my neighbors. Blood was oozing from my injury. Police did not seize my blood-stained cloth. The incident occurred 26/3/11. Blood was dropping from my injury upon the ground. Due to the cut injury, I was not able to talk at that time after stitches over my injury. I able to speak. After 2 days, police recorded my statement. 47, my lord prisoner. It is not a fact that before police, I did not state that John Kandulana had cut my upper lip. It is not a fact that Rina Kandulana and Vandana Kandulana had not quarreled with my father. It is not a fact that John Kandulana had cut me and my father. It is not a fact that to grab the land of accused persons by sending them to jail, I deposed falsely against the accused person. My lord, after going through the evidence on record, your lordship will find that, my lord, there was no contradiction amongst the PWs, my lord. All the witnesses, my lord, they stated that they did not recognize. And my humble submission is this, my lord. It is a settled principle of law, my lord. It is a settled principle of law that if there is a doubt regarding any point, that, my lord, accused person, the benefit should go to the accused person. So, my lord, sufficient contradiction, my lord. Again, my lord, dear, not seize the weapon used, and Dia also. Again, my lord, both the accused persons are above 72 years, my lord. And already they suffered, my lord, tremendous trauma, my lord, and anguish, my lord. During these 14 years, both the accused person, husband and wife, suffered sufficient, my lord, tremendous trauma, my lord. Regarding in this regard, my lord, I also we will submit that citation, my lord. Again, my lord, 11 years, 14 years is sufficient, my lord, for them. Above 72 years,
They have been in jail since when?
my lord, 23.
Only.
My lord, here, my lord, no intention also was there. This is not a case for 302. On the other hand, my lord, there is sufficient contradiction, my lord.
Sufficient contradiction, where?
Amongst the PWs, my lord, not a single claim to the eyewitness, but they stated before the court that we have not recognized the accused person. Only Dia, they recognized, but they did not state any statement that they have recognized it. My lord, prosecution in this case, my lord, would the accused person suffering, my lord, has high blood pressure and, my lord, sufficient pain that their body. Yes,
They
my
have
lord.
made sure that the deceased has no more pressure.
Again, my lord, 14 years is a long period, my lord. Tremendous, they have suffered tremendous trauma, my lord. In the pain, anguish also. So, my lord, humble submission and decision. After going through the evidence on record, your lordship will find that this is not a fit case to convict the accused person. Prosecution totally failed to prove their case beyond all reasonable doubt, my lord. So, my accused person, both the husband and wife, my lord, is entitled to get the benefit of doubt, my lord. This is my humble submission. And I am appearing as legal aid counsel in this case.
So because you are appearing as legal aid counsel, so what, we should give you,
No, my lord, that is not the
Situation.
point. That is not the point.
okay, we have to keep.
My lord, long
the end
pending
of
case.
the order. We do not forget to write that in the legal aid. That will take care, don't worry about it. That part will take care. The part that you are a legal aid counsel, that we will take care.
My lord, recently, my lord, I beg to submit one submission. 2015 Supreme Court cases, page number 497. 2000,
So which volume?
Oh, volume to go seeing. Volume, my lord, 15.
2015, we said.
2015 year, 15, SSC, my lord, page number 497. KP Singh,
417.
417. 497, my lord.
497. Para?
Para, my lord, B, C. First para, my lord, minimum, my lord, proceeding continuum nearly 17 years. No, assessed.
Okay, proportionality of judgment of the sentencing.
Again, my lord, during considering their age, my lord, above 75 years sufficient.
So now you first, when you first started your submission, they were 70 years of age. Now they're somewhere in the middle, you made them above 73. Right now you have said they're 75.
No, my lord.
If we hear you for another hour, they will become 90 years. I think.
No, my lord.
Huh?
This is at their judgment, my lord. Page number. But my lord, it's clear that they are both of 70 up above 70 years. It's clear, my lord. Judgment also it was written in the page number that he is.
So, but how does that help you? Just because they are 70, that you mean that we should lean towards them being innocent?
My lord, already they suffered, my lord, due to their considered.
What do you think?
My lord.
Do you think
And my lord, it's not.
the deceased have they suffered?
It's a suspected, my lord. They are not involved because their son, my lord, John Kandrolana inflicted the blow, my lord. It's clear, my lord. So, my lord, it's a fit case to my lord benefit of doubt. They may be released, my lord, and our court's order kindly, my lord, benefit of doubt and they entitled to get the my lord reasonable. This is
I think that's all.
submission.
Okay. Now let us hear the people.
Lordship, they are, first of all, Lordship, landed friend is saying that they are 70 years, no, Lordship.
Just for 2 minutes.
Oh, Lordship. Okay.
Yes.
Lordship, regarding the age, Lordship, in the year 2018, when the deposition was taken, page number 48, he was 60 years, about 60 years.
48.
Page 48, 313, Lordship,
He was 60 years.
60 years.
What does it matter whether it's
Lordship,
60 years?
as he is saying that 70 plus,
It's not.
not 70, and her wife is below 60. Below 60, on that regard. And Lordship, I'll not go too much, Lordship, as there are 5 injured witnesses, Lordship.
Who were the 5 injured?
5, Lordship, they were PW 1, 2, 4, and 7, and CW 1.
1, 2.
2,
four.
4, 7, and CW 1.
Okay.
And they were treated by Lordship, PW 6, the MO Lordship, that is on
But who has seen? Who has
Lordship, eyewitnesses Lordship, PW 2,
one has not seen?
no Lordship, PW 1 Lordship, no, PW 2 is there, Lordship, PW 2, then PW 7, and CW 1.
Here.
And Lord,
3 eyewitnesses.
3 eyewitnesses, Lordship.
So, this Johan was never caught, huh? Johan. His spelling is correct, Johan. So
Spelling is
very European name, not even John. Johan.
Johan Lordship.
Johan. Oh, what? Huh? Johan.
Johan only Lordship.
It's a Indian name. No. Looks like a European name. Johan. Yeah.
Actually, it was John, I think.
And the wife, Rina. It must be Rina or Rina. R-I-N-A. Maybe R-E-E-N-A, I think.
It is in 313, Your Lordship. RINA only, Lordship.
Okay.
RINA.
No problem. Yes, what else? What else?
Lordship, they have a common intention, Lordship. They have criminally trespassed, Lordship. All the witnesses, Lordship. They have said all the same, Lordship. There is a corroboration, Lordship, that they have trespassed to their house, to the accused house, Lordship, deceased house, and they have a quarrel regarding land dispute, Lordship. Then voluntarily,
The wife also.
Lordship,
Appellant number 2. There is nothing.
there is nothing but
He just followed.
they trespassed they have trespassed.
Okay, but
They trespass?
302 doesn't.
That is there. That is there. That is there, Lordship. And because other witnesses have not said, they have only instigating parties there. Or only instigating, but there is not sufficient ingredients for 302 for the wife, Lordship. But there is, Lordship, for husband
Other.
and the son.
Uh-huh.
There is.
Anything else?
No, Lordship. It may be appel, Lordship, Lordship.
No citation, nothing.
No, Lordship, I'll give citation, Lordship, regarding eyewitness, Lordship.
When?
Now, Lordship, I'll give the earlier Kartik Malhar, Lordship. I'll give. No,
I think you should look for the latest judgment now.
I have, Lordship. That also I have, but that is very prominent and that is already discussed in all,
Okay.
nearly all the. So, Lordship, the point is that it should be relevant, Lordship, and believable, Lordship.
Lordship, a point of
Just a minute, madam.
Only 2 lines, my
We
lord.
will give you time. We will give you time. Yes.
Lordship, so, Lordship, the latest also, Lordship, but as it is discussed in all the single eyewitness is sufficient, Lordship.
Why hasn't he been caught till now? This Johan.
Lordship, that Lordship, I have no such instruction that right from that. But in the IO Lordship, I have seen let me check, Lordship, that PW10 Lordship somewhere.
Was there any cross FIR filed or anything? Nothing.
No, Lordship.
That's all? Okay, you give the citation.
Lordship.
Just finish. Yes, madam, you can tell us.
My lord, regarding their age, this judgment was delivered by learned lower court. Sentence hearing, my lord.
Uh-huh.
I have heard accused Vandana Kandulana and Rina Kandulana. On the point of sentence as provided under section 235 CRPC, it is submitted that age of both the accused are increasing and stated that the age of the accused Vandana Kandulana is 70 years. This order was passed on just
Stated by the lawyer probably.
and age of the accused Rina Kandulana is 65 years. Apart from that, accused Rina Kandulana has
Look,
been.
madam, the issue is this. Whether the conviction is to be upheld or not. It's only after that issue is decided that maybe we will go into whether the sentence they could have been given a lighter sentence. If convicted under 302, that's the minimum sentence that can be given.
My lord, this is not from my.
I understand. If we hold that it's 302, then only the issue of sentence will come. There also only up till the minimum, nothing less than that.
Come down, my lord, this is from my heart,
Wish-
submission, but this is not it is for granted to so come down to the benefit of doubts, my lord.
Benefit of doubt, but the doubt has to be shown first. Benefit of doubt, we cannot just apply mechanically. Okay, right. Right. Mrs. E.B. Borderline, then legal aid counsel for the appellant. Appellants. Also heard Ms. A. Begum, then additional PP for the state. This appeal is directed against the impugned judgment and order dated 24/5/2023, passed by the learned Sessions Judge Thomas Smith Montesquieu in Sessions case number 78 of 2012, arising out of Textbook case number 294 of 2011, by which the appellant have been convicted under section 447/34, 323/34, and 302/30. Stop. The sentences are to run concurrently. Were directed to be run concurrently. Stop. The prosecution case in brief is that an FIR dated 27/3/2011 had been submitted by the prosecution witness -1, bracket PW1. Stating that the appellant along with their son, Shri Johan or Jahan? J-O or J-A?
JOHN, my lord.
Johan Kandula. Kandula. Kandulana. Kandula. Possibly entered into their home and assaulted her husband, father-in-law, Shri Badur Kandula, and brother-in-law. With thou and sticks. As a result, her husband sustained serious injury from a dove, while the father-in-law, and along with the father-in-law, while the father-in-law sustained head injury. When did he die? He did not die straight away.
No, Lordship, after 3 days, he succumbed to his.
Consequently, Saloni Bari OP TDE number 566 dated 27/3/2011 was registered at 11 a.m. and the same was forwarded to the officer in charge of the Tezpur police station for registering it. Thus, this could be a case number 294/11 under section 447/326/307/34 Act was registered by GDE number 1419 dated 27/3/11. Full stop. Next step. The PW 10 was appointed as the investigating officer to investigate the case. After investigation of the case by the 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 PW 10 prima facie case against the appellant, including their son Johan Kandulana. Under section, before that, during investigation of the case, comma, the father-in-law of PW1 expired on, when did he die? No one mentions his death.
One for 2000.
Where is that? Please.
Is 120 or so.
Yes, one for 2011. So what about it? Under section 447/323/302/5 PC. Next part. The learned court thereafter charges against the appellant and the absconding Johan Kandulana no, not only enough. With not the absconding, not the against the appellant under section 447/34, 323/34 and section 302/34, to which they pleaded not guilty and claimed to be tried. No charge had been framed against the co-accused Johan Kandulana, who was the son of the appellant, in as much as he had absconded and the police were unable to face it. First. Next paragraph. The learned trial court thereafter examined 10 prosecution witnesses and 1 court witness, comma, no, 1 court witness. The appellants examined under section 3(1) CCR, wherein they denied all the evidence that had been adduced against. The learned trial court thereafter came to a finding that the appellant were guilty no, were guilty of the offense under section 44734, comma 32334, and 30234. And that such convicted for the theft. The appellants were thus awarded, were thus sentenced as per the following. Page 102 in bold. Next para. The no, being aggrieved, the appellants who are husband and wife have filed the present appeal. The learned counsel for the learned counsel for the appellant submits that there was no weapons recovered by the police to prove that the appellants had assaulted the deceased with weapons. He submits that the evidence in fact does not indicate that there was any assault made by the appellants on the deceased. The evidence adduced by the prosecution witnesses only points to the guilt of the son of the appellant, that is Johan Kandulana, who had absconded. Next para. The learned legal aid counsel further submit that there is sufficient contradiction in the evidence of the prosecution witness to have enabled the learned trial court to dismiss the prosecution case. In as much as there was no corroboration of the testimony of the prosecution witness by other witnesses. Pushpa. Even, so you said there is no eyewitness or there is eyewitness?
My lord, claimed to be the eyewitness, but the cross-examination himself stated that he did not.
Which one? Which one? PW?
Two, BW two, my lord.
Only PW2, not no one else. He also submitted that. Though PW2 had claimed to be an eyewitness.
Four also, my
2 and 4 had claimed to be. 2 and 4. They are not here. 2 and 4 had claimed to be. 4 had claimed to be an eyewitness. They were not. Come on, they were. A reading of their testimony would show that they were not eyewitnesses to the assault made on the deceased person. He also submits that the evidence of PW 1, 3, and 5 was all hearsay evidence. The learned legal aid counsel further submits that when the evidence of the witnesses show that the incident had occurred at night and the witnesses could not recognize the persons present at the place of occurrence. There was no guarantee that the appellants were present. There was no proof. There was no proof that the appellants were present at the place of occurrence at the time of the incident. It thus submits that when there are two views possible on the subject, on a particular issue, on a particular uh, on a particular evidence in issue, comma, the view in favor of the accused would have to be accepted by this court. She also submits that as the appellants are above 70 years old, comma, their case should be considered leniently. What? How do we consider, because they are old, how do we consider their case? We consider them what?
This is from my submission, my lord. My lord, this is not a fit case for 302, my lord. No intention, and my lord.
No, I'm talking about the age, madam. Age,
Age.
because they're 70.
My lord, 14 years, my lord, they suffered sufficient, my lord.
So yeah, so even if they are proven guilty, that means that's what they're saying.
No, my lord,
If they're proven guilty, they should be released as they are 70 years of age. Is that?
set off also, my lord, it court discretionary power, so already they
Can we
suffered.
say that they should be considered innocent because they are 70 years of age?
No, my lord, my humble submission is this. It's a no, my lord, eyewitness, and my lord, John Kandulana was the main.
Where is the question of age come in these cases?
Yes, my lord. Above 70, there are, in this regard, there are sufficient rulings also, my lord.
No. Okay, cut that age portion. No, that's neither here nor there. How can we, just because a person is 150 years old, he should be regarded as innocent? How can it be?
No, my lord.
I don't know what you're trying to get at. The only thing you can say is if he is found to be guilty, if they're found to be guilty, their cases should be considered sympathetically as they are old persons. That I can understand. Otherwise, we cannot, just because they're old, we cannot take a lenient view.
No, my lord, my humble submission is this, my lord. As my lord, your prosecution totally failed to prove the
That
case.
is a different thing.
That's
Okay,
what
okay, then we cut that.
submission is
Fine.
this.
Okay, we heard that. Next. She also submits that as the appellants are above 70 years of age, comma, the court while awarding sentence, the Learned Trial Court while passing the sentence upon the appellant should have considered their age and awarded the sentence proportionately to their according to their age. Huh? Is that what you want? I don't know. According to the age. Huh? Miss Para, Miss Abigam, no, she accordingly submits that the impugned judgment and order should be set aside and the appellant should be acquitted. Next para, Miss Abigam, the learned APP, on the other hand, submit that there are 5 injured witnesses who had suffered the attack on the fateful night in the house of the deceased. They are PW 1247 and CW-1. He submits that out of the 5 injured witnesses, PW 2,7 and CW-1 were eyewitnesses to the attack on the to the assault on the injured injured witnesses and the deceased. Poster. She also submits that the injured witnesses, that is PW 1247 and CW-1, were treated by PW 6, who was a medical officer, was a doctor. The learned APP further submits that the ages of the appellants cannot be beyond 70 years as on date, in view of the fact that the age of the appellant number 1 was 60 on 12/10/2008, when his examination under section 313 CRPC had been recorded. Similarly, the age of the appellant number 2 was 50 years on 12/10/2018, when she was examined under section 313 CRPC. Only 6 years having passed since then, they could not be beyond 66 years. No.
57.
7 years, 67 years.
Beyond, below 60.
No, they could not be beyond 7. They could not be beyond, they could not be, they could not be beyond 67. You say, the appellant number 1 could not be beyond 67 years and the appellant number 2 could not be beyond 57 years. He submits, the learned APP submits that there are eyewitnesses to the time in question. Besides, they have been injured witness. There is no infirmity with the impugned judgment order. Accordingly, the appeal should be dismissed. have heard the learned counsel for the party. The evidence of PW1 brackets informant is to the effect that the appellant and Johan had come to their house on 26/4/2003 at about 9 p.m. and assaulted his father-in-law, assaulted her father-in-law, Badur Kandulana, with an axe. Johan had inflicted the axe blow on the deceased, that is Badur Kandulana. Further, there was a land dispute between the deceased, her deceased father-in-law, and the appellant number one, who were brothers. He had recognized the accused person in the darkness of the night on the basis of the light given off by a lamp, bracket diya, DIY. The deceased was the deceased who was in an injured condition at that time was thereafter shifted to civil hospital Tesco and thereafter to Mission Hospital at Lynn. He was again shifted to the GMCH Guwahati. However, he succumbed to his injuries after 3 days. PW1 further stated that her husband, PW, oh, he's not a thing. Salai Kandulana is not a thing. He's not a witness. Husband of PW1.
The CW1.
Okay. What have I said? CW-1 also suffered injuries and had been treated in Anak Lata Civil Hospital test, and that her husband had now recovered from his injury. In the cross-examination of PW1, the PW1 had denied the suggestion. He is not hearsay evidence. Huh? No, no, she is not here. She denied the suggestion that she did not tell the police that she had seen the accused person assaulting her father-in-law with an axe. Let's come. The evidence of PW2 is to the effect that there was a land dispute between the family of the appellant and the deceased, who were brothers. The appellants and their son, Johan Kandulala, came to their house and inflicted and hit the deceased father and hit his deceased father and brother CW-1 with an axe. With which the deceased was taken to a hospital. In his cross-examination, PW2 has not budged from his testimony that the appellant and Johan had assaulted the deceased with an axe. Or that they did not assault his elder brother, Salai Kandulana. Even though suggestions to the contrary were put to PW2. Next paragraph. The evidence of PW3 is only hearsay evidence, as his entire deposition is based on what he has heard from others. Next. The evidence of PW4 is to the effect that he knew both the family of the appellants and the deceased. And that while he was standing in the courtyard of the house of it's a joint family over. They were they were sleeping together.
Adjacent household.
As when they had rushed to the house of the appellant, he saw the appellant number one hitting the head of the deceased with a dove. He also saw the appellant number one and his son responding together hitting Selai Kandulana, but CW-1 with a dove on his face. He further stated that he saw the entire incident from the light given off by a candle. He further stated that in his cross examination, PW4 stated that he saw the appellant number one inflicting a dove blow on the head of the deceased from behind. Next slide. The evidence of PW5 is hearsay evidence as the same is based on the information received from us. Next part. The evidence of PW6, who is a medical officer, is to the effect that he had examined three injured persons, that is Srimati Sunita Kandulana, bracket PW1, Sushil Horo, bracket PW7, Ram Kandulana, bracket PW. In his where is this report of this PW6?
Lordship, it is on page number 32, Lordship. The injury were extra.
No. I want to see the medical document report document. 104. 104. The opinion of PW6 to the injuries caused PW1, PW7, and PW2 is to the effect that the injuries were approximately is to the effect that that the examination was done on 27th 2011 at around 1 a.m. 1 a.m. and that the injury was approximately 24 hours old, simple in nature and caused by blunt object. A blunt type of object. It will be a blunt object. Blunt object. Blunt. Next one. The evidence of PW7, who is an eyewitness, is to the effect that he was sitting in the house of the deceased at the time when there was an altercation between the deceased and the appellant, including Johan Kandulana. So thereafter, Johan Kandulana assaulted the deceased on his head with a dao. Johan also assaulted Selai Kandulana, bracket CW-1, on his face, the dao. The appellant number one, the deceased thereafter fell down and blood was oozing out from his injuries. Selai Kandulana, bracket CW1, also sustained injury on his face and blood was oozing out from his injury. The appellant number 2 and appellant number 1 were instigating Johan Kandulana to assault Bandur Kandulana. PW7 further testified that he had tried to prevent the assault. Next paragraph. The evidence of PW8 is to the effect that he was working as a medical and health officer at GMC8 on 4/2011, when he conducted the autopsy on the body of the deceased. The finding of PWA on the injuries sustained sustained by the deceased is to the following. Page 36, injuries, 1 to 7. So, in the opinion of PWA, the cause of death, as a result of injuries sustained over the head, as described in the autopsy report. All injuries were anti-mortem and caused by a blunt force impact, except injury number 1 and 5. However, this up. Next para. The evidence of PW9 is to the effect that he was the second investigating officer who had submitted the charge, while the evidence of PW10 was the first investigating officer is to the effect that he had investigated the case, the case, and taken the and recorded the statement of the witness, etc. On perusal of the evidence produced by the learned trial court, we find that there has been no recovery of the weapons used for assaulting the deceased and the other family members of the deceased. It is clear from the evidence that there has been injuries caused only to the family of the deceased, and no injury has been caused on the appellant and Johan Kandulana. Johan Kandulana, the son of the appellant, number 1, has also absconded after the assault made on the deceased. The evidence of the eyewitnesses number 1, 2, 7, and CW1 clearly goes to show that the deceased was attacked with a weapon by the appellant, number 1, and Johan Kandulana. The assault on CW1 had also been made by Johan Kandulana. Next paragraph. On considering the evidence recorded by the learned trial, they are of the view that even though no weapons have been recovered by the police, the testimony of the eyewitnesses number PW1, 2, 7, and CW1 show that the assault on the deceased by by appellant number one and the absconding Johan Lana has been proved. Muslim. We also do not find any contradictions in the evidence of the prosecution witness. On considering all the above facts, we do not find any ground to come to any other conclusion except the fact that the death of the appellant had been caused, disease had been caused due to the action of the appellant number one and the absconding Johan so and so. Should we talk about Johan? Johan, there's no Chachi Ross.
No, Lord.
By the appellant number one. Appellant number one. Otherwise, we'll be convicting him without.
Lord, yes.
Don't say about Johan on the appellant number one. Accordingly, we do not find any grounds to interfere with the finding of the learned trial court with regard to the conviction of the appellant number one under section those three. Next para. The above being said, the only evidence adduced against the respondent number, appellant number one, is in the cross-examination, I think. Yeah, instigation.
Rina and Bandana Kundina were instigating John.
By the evidence submit is by the testimony of PW7, who stated that inverted commas, Rina and Bandhan Kandulana were instigating Johan Kandulana to assault Badur Kandulana. Inverted commas, page 34. Page 30. On considering the above statement and keeping in view that there is no other incriminating evidence against the appellant number two, we are unable to come to a conclusion that the appellant number two could be said to have any common intention to kill the deceased. Huh?
Common intention was there because they came by trespassing and
No,
Maybe-
but then you see, they come. You see, they do a lot in show only.
Lord,
They come with weapons. Then they started a quarrel. Because if they wanted to kill, there was no need for a quarrel.
Lord,
There's no need for a quarrel. Because if you're going to kill, where's the requirement for a quarrel? You come, chop, and you go.
Lord.
But
Yeah,
they came, they
altercation
started, then they started arguing.
The
Blood,
heat of the
blood
moment they
pressure
have.
went up, and then they did it. That usually happens.
That moment she may say.
And you see, I don't think an entire family will decide, okay, let's go and kill, and they will all go and, I don't think that is not, just think about it. It doesn't seem realistic. The other aspect,
Trespass is there.
as far as they will see, okay, we'll say, basically, maybe. We have, CAV, huh? CAV.
Lordship, if Lordship permits me, make a mention as regard number 7.
You have not given me citation?
I have been,
Okay. Just give me. Just
yeah,
a minute.
14. I have not done it.
Oh, I've got a meeting.
Lordship, here in this matter, last item, my lord,
Uh-huh.
a report was called for
Ah.
from the IGP. It has been received regarding remission. Report I
Right.
have already given in the event of the matter. Matter of
Just give me that report.
are already submitted, 2 copies.
There is the order.
This accused appellant, he has been sent to lordship, transferred to Central Prison, Madurai, Tamil Nadu. 8/3/2021.
So what is to be done now?
Now
And
they
for
will
his
place,
revision has been communicated for written after the
after the vacation,
yes.
remission, but otherwise also lordship on the
Right in the next agency, will be where additional PP has submitted a letter dated 22/9/2025 issued by the IG of Prisons, Assam, stating that all required documents have been submitted and placed before the Assam, before the Assam State Level Review Board for consideration of the case of the appellant for remission. This is the matter on
lordship in the 10th of November.
10th of November.
That will be kept on record.
This is on 10th of November.
That will be kept on record, your lordship.
It will be, we have mentioned it.
Right.
We mentioned. Okay, so, this.